Hello, welcome to Deb's True Crime Notebook, the home of Snowmageddon. That's right, we had a snowstorm last night. 9 inches of snow on the ground. It is truly beautiful, but I hope to get the roads cleared because I have things to do and places to go and people to see. I hope you guys are safe and warm wherever you are. I'm going to warn you that this is going to be a long video, and it's very dry legal information. So put your headphones in and go listen while you do something else. Let's revisit the motion from Amy E. Carrozza. She's the state public defender for the state of Indiana. I certify that on December 30th, 2024, I served this motion for authorization to appoint 2 appellate attorneys upon Carroll County Prosecuting Attorney Nicholas McClellan and defense attorneys Andrew Baldwin and Bradley Rosie by electronic service through the Indiana e-filing system. And it's respectfully submitted by Amy E. Carrozza. Again, she's the Indiana State Public Defender. State of Indiana versus Richard M. Allen. Order. The state public defender files a motion for authorization to appoint 2 appellate attorneys. The court authorizes the state public defender to appoint 2 attorneys to perfect the direct appeal in this cause. It is signed January 3rd, 2025 by the Honorable Francis Gull, Special Judge, Carroll Circuit Court. Let's take a look at the Indiana rules for Post Conviction Remedies. Section 1, remedy to whom available conditions. A. Any person who has been convicted of or sentenced for a crime by a court of the state and who claims 1. That the conviction or the sentence was in violation of the Constitution of the United States or the Constitution of laws of this state. 2. That the court was without jurisdiction to impose sentence. 3. That the sentence exceeds the maximum authorized by law or is otherwise erroneous. 4. That there exists evidence or material facts not previously presented and heard that requires vacation of the conviction or sentence in the interest of justice. 5. That this sentence has expired, his probation, parole, or conditional release unlawfully revoked, or he is otherwise unlawfully held in custody or other restraint. 6. That the conviction of sentence is otherwise subject to collateral attack upon any ground of alleged error heretofore available under any common law, statutory, or other writ, motion, petition, proceeding, or remedy. May institute at any time a proceeding under the rule to secure relief. B. This remedy is not a substitute for a direct appeal from the conviction and or sentence, and all available steps, including those under PC2, should be taken to perfect such an appeal. Except as otherwise provided in this rule, it comprehends and takes the place of all other common law, statutory, or other remedies hereforto available for challenging the validity of the conviction or sentence as it shall be used exclusively in place of them. C. This rule does not suspend the writ or habeas corpus, but if a person applies for a writ or habeas corpus in the county where the person is incarcerated and challenges the validity of his conviction or sentence, that court shall transfer the cause to the court in which the conviction took place, and the latter court shall treat it as a petition for relief under this rule. D. A petition filed by a person who has been convicted or sentenced for a crime by a court or the state that seeks to require forensic DNA testing or analysis or any evidence, whether denominated as a petition filed pursuant to Indiana Code 35-38-7-5 or not, is considered a petition for post-conviction relief. E. A petition seeking to present new evidence challenging the person's guilt or appropriateness of the person's sentence when brought by a person who has been sentenced to death and or completed state post-conviction review proceedings, whether denominated as a petition filed pursuant to Indiana Code 35-50-2-NK or not, is considered a successive petition for post-conviction relief under Section 12 of this rule. Section 2 Filing. A person who claims relief under this rule or who otherwise challenges the validity of conviction or sentence must file a verified petition with the clerk of the court in which the conviction took place, except that a person who claims that the person's parole has been unlawfully revoked must file a verified petition with the clerk of the court in the county in which the person is incarcerated. 3 copies of the verified petition must be filed and no deposit or filing fee shall be required. The clerk shall file the petition upon its receipt and deliver a copy to the prosecuting attorney of that judicial circuit. In capital cases, the clerk shall, in addition to delivering a copy of the petition to the prosecuting attorney, immediately deliver a copy of the petition to the Attorney General. If an affidavit of indigency is attached to the petition, the clerk shall call this to the attention of the court. The court finds that the petitioner is indigent. It shall also petition to proceed in form of papyrus. If the court finds the indigent petitioner is incarcerated in the Indiana Department of Correction and has requested representation, it shall order a copy of the petition sent to the public defender's office. Okay, let me give you a few explanations here to help you understand what we just read. It's a lot of legal jargon, I know. So indigency is just the form of indigent, means he doesn't have means to pay, low income. And in form of pauperous, it's a Latin phrase and it means in the manner of pauper. You've heard of people being referred to as a pauper. It refers to a legal process that allows someone who can't afford to pay the filing fees or lawsuit or appeal to proceed without paying those fees. Hope that helps you understand what we just read. Section 3, Contents. A. The petition shall be submitted in a form in substantial compliance with the standard form appended to this rule. The standard form shall be available without charge from the public defender's office, who shall also see the forms are available at every penal institution in this state. B. The petition shall be made under oath, and the petitioner shall verify the correctness of the petition, the authenticity of all documents and exhibits attached to the petition, and the fact that he has included every ground for relief under Section 1 known to the petitioner. C. Documents and information excluded from public access pursuant to the rules of access to court records shall be filed in accordance with Trial Rule 5G. Section 4, Pleadings. A. Within 30 days after the filing of the petition or within any further reasonable time, the court may fix the state by the Attorney General in capital cases or by the prosecuting attorney in non-capital cases. It shall respond by answer stating the reasons, if any, why the relief prayed for should be granted. The court may make appropriate orders for amendment of the petition or answer, for filing further pleadings or motions, or for the extending of time or the filing or any pleading. B. Within 10 days of filing a petition for post-conviction relief under this rule, the petitioner may request a change of judge by filing an affidavit that the judge has a personal bias or prejudice against the petitioner. The petitioner's affidavit shall state the facts and the reasons for that belief that such bias or prejudice exists, and shall be accompanied by a certificate from the attorney of record that the attorney in good faith believes that the historical facts recited in the affidavit are true. A change of judge shall be granted if the historical facts recited in the affidavit support a rational inference or bias or prejudice. For good cause shown, the petitioner may be permitted to file the affidavit after the 10-day period. No change of venue from the county shall be granted. In the event a change of judge is granted under the section, the procedure set forth in Indiana Administrative Rule 21 shall govern the selection of a special judge. C. At any time prior to entry of judgment of the court may grant leave to withdraw the petition. The petitioner shall be given leave to amend the petition as a matter of right no later than 60 days prior to the date the petition has been set for trial. Any later amendment of the petition shall be by leave of the court. D. If the petition is challenging a sentence imposed followed of a plea of guilty, The court shall make the transcript part of the record. E. In the event that counsel for petitioner files with the court a withdrawal of appearance accompanied by counsel's certificate, see Section 9C. This case shall proceed under these rules, petitioner retaining the right to proceed pro se in form of pauperis if indigent. Thereafter, the court may order the state public defender to represent as indigent incarcerated petitioner if the court makes a preliminary finding that the proceeding is meritorious and in the interest of the justice. F. If the state public defender has filed an appearance, the state public defender shall have 60 days to respond to the state's answer to the petition filed pursuant to Rule PC 1-4A. If the pleadings conclusively show that petitioner is entitled to no relief, the court may deny the petition without further proceedings. G. The court may grant a motion by either party for summary disposition of the petition when it appears from the pleadings, depositions, answers to interrogatory admissions, stipulations of fact, and any affidavit submitted that there is no genuine issue of material fact and the moving party is entitled to judgment as a matter of law. The court may ask for oral argument on the legal issue raised. If an issue of matter of fact or material fact is raised, then the court shall hold an evidentiary hearing as soon as reasonably possible. Section 5 Hearing. A petition shall be heard without a jury. A record of the proceedings shall be made and preserved. All rules and statutes applicable in civil proceedings, including pretrial and discovery proceedings, are available to the parties, except as provided above in Section 4B. The court may receive affidavits, depositions, oral testimony, or other evidence and may, at its discretion, order the applicant brought before it for the hearing. The petitioner has the burden of establishing his grounds for relief by a preponderance of the evidence. Section 6 Judgment. The court shall make specific findings of fact and conclusions of law on all issues presented, whether or not a hearing is held. If the court finds a favor for the petitioner, it shall enter an appropriate order with respect to the conviction of sentence in the former proceedings and any supplementary orders as to arraignment, retrial, custody, bail, discharge, correction of sentence, or other matters that may be necessary and proper. This order is a final judgment. Section 7 Appeal. An appeal may be taken by the petitioner or the state from the final judgment in this proceeding under rules applicable to civil actions. Jurisdiction for such appeal shall be determined by reference to the sentence originally imposed. The Supreme Court shall have exclusive jurisdiction in cases involving an original sentence of death, and the Court of Appeals shall have jurisdiction in all other cases. Section 8. Waiver of or failure to assert claims. All grounds for relief available to a petitioner under this rule must be raised in his original petition. Any ground finally adjudicated on the merits are not so raised and knowingly, voluntarily, or intelligently waived in the proceeding that resulted in the conviction or sentence, or in any other proceeding the petition is taken to secure relief, may not be the basis for subsequent petition, unless the court finds a ground for relief asserted which, for insufficient reason, was not asserted or was inadequately raised in the original petition. Section 9. A. Upon receiving a copy of the petition, including an affidavit of indigency from the clerk of the court, the public defender may represent any petitioner committed to the Indiana Department of Correction in all proceedings under this rule, including appeal. If the public defender determines the proceedings are meritorious and in the interest of justice, the public defender may refuse representation in any case where the conviction or sentence being challenged has no present penal consequences. Petitioner retains the right to employ his own counsel or to proceed pro se, but the court is not required to appoint counsel for a petitioner other than the public defender. B. In the event petitioner elects to proceed pro se, what that means is public defender, the court at its discretion may order the cause submitted upon affidavit. It need not order a personal presence of the petitioner unless the presence is required for a full and fair determination of the issues raised at the evidentiary hearing. If the pro se petitioner requests assurance of subpoenas for witnesses at an evidentiary hearing, the petitioner shall specifically state by affidavit the reason the witness's testimony is required and the substance of the witness' expected testimony. If the court finds the witness testimony would be relevant and probative, the court shall order the subpoena be issued. If the court finds the proposed witness testimony is not relevant and probative, it shall enter a finding on the record and refuse to issue the subpoena. Petitioners who are indigent and proceeding in forma pauperis shall be entitled to production of guilty plea and sentencing transcripts at public expense prior to a hearing. If the petition is not dismissed, in addition, such petitioners shall also be entitled to a record of the post-conviction proceeding at public expense for appeal of the denial or dismissal of the petition. C. Counsel shall confer with petition and ascertain all grounds for relief under this rule, amending the petition if necessary to include any grounds not included by petitioner in the original petition. In the event that counsel determines the proceeding is not meritorious or in the interest of justice, before or after an evidentiary hearing is held, counsel shall file with the court's counsel withdrawal of appearance, accompanied by counsel's certification that 1. The petitioner has been consulted regarding grounds for relief in his pro se petition and any other possible grounds, and 2. Appropriate investigation, including but not limited to review of the guilty plea or trial and sentencing records, has been conducted. Petitioner shall be provided personally with an explanation of the reasons for withdrawal. Petitioner retains the right to proceed pro se in forma pauperis if indigent after counsel withdraws. D. State in non-capital cases, the prosecuting attorney of the circuit in which the court of convictions is situated shall represent the state of Indiana in the court of conviction. In capital cases, the attorney general shall represent the state of Indiana for purposes of answering the petition, and the prosecuting attorney shall, at the request of the attorney general, assist the attorney general. The attorney shall represent the state of Indiana on any appeal pursuant to this rule. Section 10, Subsequent Prosecution. A. If prosecution is initiated against a petitioner who has successfully sought relief under this rule and a conviction is subsequently obtained, or B. If a sentence has been set aside pursuant to this rule and the successful petitioner is to be resentenced, then the sentencing court shall not impose a more severe penalty than the originally imposed unless the court includes in the record of sentencing hearing a statement of the court's reasons for selecting the sentence that is imposed, which includes reliance upon identifiable conduct on the part of the petitioner that occurred after the imposition of the original sentence, and the court shall give credit for time served. C. The provisions of subsections A and B limiting the severity of the penalty do not apply when 1. A conviction based upon a plea agreement is set aside, 2. The state files an offer to abide by the terms of the original plea agreement within 20 days after the conviction is set aside, and the defendant fails to accept the terms of the original plea agreement within 20 days after the state's offer to abide by the terms of the original plea agreement is filed. Section 11. Definition. Whenever public defender is mentioned herein, it shall mean the public defender of the state of Indiana as defined by statutes. Section 12. Successive petitions. A. A petitioner may request a second or successive petition for post-conviction relief by completing a properly and legibly completed successive post-conviction relief Rule 1 petition form in substantial compliance with the form appended to this rule. Both the successive post-conviction relief Rule 1 petition form and the proposed successive petition for post-conviction relief shall be sent to the Clerk of Indiana Supreme Court, Indiana Court of Appeals, and Tax Court. B. The court will authorize the filing of the petition if the petitioner establishes a reasonable possibility that the petitioner is entitled to post-conviction relief. In making this determination, the court may consider applicable law, the petition and materials from the petitioner's prior appellate and post-conviction proceedings, including the record, briefs, and court decisions, and any other material the court deems relevant. C. The court authorizes the filing of the petition. It is to be 1. Filed in the court where the petitioner's first post-conviction relief petition was adjudicated for consideration pursuant to this rule by the same judge if that judge is available. And 2. Referred to the state public defender who may represent the petitioner as provided in Section 9A of this rule. Authorization to file a successive petition is not a determination on the merits of any other purpose and does not preclude summary disposition pursuant to Section 4G of this rule. Rule PC2, belated notice of appeal, belated motion to correct error, and belated appeal. Effective January 1st, 2012 is when this was developed. Eligible defendant defined an eligible defendant for purposes of this rule is a defendant who, but for the defendant's failure to do so timely, would have the right to challenge or direct appeal and conviction or sentence after a trial of plea or guilty by filing a notice of appeal, filing a motion to correct error, or pursuing an appeal. Appellate court jurisdiction. Jurisdiction of an appeal under this rule is determined pursuant to Rules 4 and 5 of the Indiana Rules of Appellate Procedure by reference to the sentence imposed as a result of the challenge conviction sentence. Section 1, belated notice of appeal. A, required showings. An eligible defendant convicted after a trial or plea of guilty may petition the trial court for permission to file a belated notice of appeal of the conviction of sentence if 1. The defendant failed to file a timely notice of appeal. 2. The failure to file a timely notice of appeal was not due to the fault of the defendant. And 3. The defendant has been diligent in requesting permission to file a belated notice of appeal under this rule. B. Form of petition. There is no prescribed form of petition for permission to file a belated notice of appeal. The petitioner's purpose notice of appeal may be filed as an exhibit to the petition. C. Factors in granting or denying permission. If the trial court finds that the requirements of Section 1A are met, it shall permit the defendant to file the belated notice of appeal. Otherwise, it shall deny permission. D. Hearing. If a hearing is held on a petition for permission to file a belated notice of appeal, it shall be conducted according to Indiana Post-Conviction Rule 1.5. F. Time and procedure for initiating appeal. If the court grants permission to file a belated notice of appeal, the time and procedure for filing such notice of appeal is governed by Appeal R9A. Section 2, belated motion to correct error. A. Required showings. An eligible defendant convicted after a trial or plea of guilty may petition the court of conviction for permission to file belated motion to correct error addressing the conviction or sentence it. 1. No timely and adequate motion to correct error has been filed for the defendant. 2. The failure to file a timely motion to correct error was not due to the fault of the defendant. And 3. The defendant has been diligent in requesting permission to file a belated motion to correct error under this rule. B. Merits of motion. The trial court shall not consider the merits of the motion until it has determined whether the requirements of Section 2A are met. C. Hearing. Any hearing on whether the petition should be granted shall be conducted according to PCR 1.5. D. Factors in granting or denying permission. If the trial court finds the requirements of Section 2A are met, it shall permit the defendant to file the motion, and the motion shall then be treated for all purposes as a motion to correct error filed within the prescribed period. E. Appealability or denial of permission. If the trial court finds that the requirements of Section 2A are not met, it shall deny defendant permission to file the motion. Denial of permission shall be a judgment and a final judgment for purposes of Appeal R5. F. Time for initiating appeal. The time for filing a notice of appeal from denial of permission is governed by Appeal R9A. Section 3, Belated Perfection of Appeal. An eligible defendant convicted after a trial or plea of guilty may petition the appellate tribunal for permission to pursue a belated appeal of the conviction of sentence if A. The defendant filed a timely notice of appeal, B. No appeal was perfected for the defendant or the appeal was dismissed for failing to take a necessary step to pursue the appeal, C. The failure to perfect the appeal or take the necessary steps was not due to the fault of the defendant, and D. The defendant has been diligent in requesting permission to pursue a belated appeal. Now, guys, I know this video was long and dry because it's full of legal jargon and most of it is like nonsensical to us. However, I thought it was important to go ahead and document all of this and put it up so that as we move forward in the appeal process, you can refer back to this video, Posting Indiana Rules for Post Conviction Remedies, to help you better understand what's going on in the case. And I will try to refer back to it as things do pop up. So I hope that you were able to stick with us to the end. If you cannot stick with it to the end, just turn it down and let it play in the background. And, let's keep this up and documented so that you can refer back to the rules of post-conviction relief. We'll see you next time as this continues to proceed forward in the Court of Appeals. If you have any questions about anything that you listen to here, post them in the comment section. We love to hear your comments, and I will do my best to answer them. If I don't know the answer, I'll find someone who does. Don't forget to like, subscribe, share this with your friends. Again, leave us comments, and we'll see you next time on Deb's True Crime Notebook.